Thank you all very much. Please be seated.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont versus Rebekah S. VanBuren, docket number 2016-253. Representing the appellant, the State of Vermont, is Benjamin Battles. Seated at counsel table with Attorney Battles is Alexander Burke. Also seated at counsel table with Attorney Battles is Bridget Acey, who is representing the Cyber Civil Rights Initiative as amicus curiae. Representing the appellee, Rebekah VanBuren, is Don Matthews.
Thank you very much, counsel.
Good afternoon, Your Honors.
Good afternoon.
In 2015, following months of debate and negotiation, the General Assembly enacted a law specifically targeting non-consensual pornography, a well-documented national problem that can devastate victims' lives, the vast majority of whom are young and female. More than 30 other states have passed similar laws in recent years, and several others have legislation currently pending.
Do I take it right, Mr. Battles, not seeing any equivalent cases to this one in any of those other 37 states, that there is no, this is in fact the first appellate decision on the constitutionality of a revenge porn statute?
I did come across one after the reply brief was filed that was decided by a California trial court. It's called People v. Iniguez, I-N-I-G-U-E-Z, and that's at 247 Cal App 4th Sup 1, in which they upheld California's law.
Does California's law simply preclude knowingly disclosing a visual image of an identifiable person who was nude or engaged in sexual conduct, just plain old nude?
I believe it does.
Just nude,
believe
not
so.
obscenely nude, not provocatively nude, just naked.
I believe it was, the definitions were similar to Vermont's.
Similar?
I'm sorry, I don't have the exact language in front of me. But it did uphold the statute against an overbreadth challenge. And then there is another case pending in Vermont that's been in Chittenden County before Judge Pearson that's been fully briefed, but no decision. The court should reverse the decision below and hold the statute constitutional. The statute regulates unprotected speech that should not be subject to strict scrutiny. But regardless of what level of scrutiny applies, the statute should survive because it is narrowly tailored to advance compelling state interests. And turning to the issue of strict scrutiny, there's no First Amendment right to publicize without consent someone's nude private pictures. And we think strict scrutiny can be avoided and should be avoided in essentially two ways. And the first is that the statute targets conduct that should be understood as obscenity. Extremely offensive communications that depict nudity or sex. And applying the Miller v. California framework to this statute, there's three prongs. It needs to appeal to the prurient interest, depict patently offensive sexual conduct as defined by the law, the state law at issue, and that it lacks serious value.
But nudity alone is not enough to make material legally obscene.
That's correct.
So in this case, you went in with a stipulated set of facts, and none of which say that this was anything other than a nude picture.
That's right. That's
So
our argument under Miller, and I think it's important to spell that out, is sort of, I don't think there's really a dispute about the prurient prong, the first one, that it's in some sense appeals to, sexual interest, or the lack serious value, because that's covered by the exceptions to the statute.
if I send you a picture of the David, are you telling me that I'm appealing to your prurient interests?
I think you need to, it's a mushy analysis. I think obscenity always is, but it's, you have to look at community standards, and is this, the way it's presented, is this something that is likely to arouse sexual interest in a reasonable way?
As you've defined it, was this obscene when it was originally sent?
No, and the reason why I think we get to obscenity is because there's one, if you go to the second prong, that's kind of divided into two parts. And one, does it depict sexual conduct? And in Miller itself, the court said that could include lewd exhibition of the genitals, and subsequently the court has said that there's really no difference between that and lewd exhibitions of nudity. And then so that's essentially nudity right there. And then the other element is it patently offensive? And our argument is that you have the nudity, you have the sexual conduct defined under the statute, and what gets you to the patently offensive part is the fact that it was disclosed without consent and a violation of privacy.
But it was sent without consent too, right? I mean, the guy didn't ask to have it sent.
That's
Made
correct.
by disclose.
But it wasn't sent to the defendant, and she disclosed it without consent.
Well, it was sent to someone who didn't ask for it.
I'm having trouble relating this part of your argument to the way you opened. So let me try it this way. We just heard, I don't know if you were here or not, I know you submitted an amicus brief in the KKK case, the question of whether it was a true threat, on the understanding that if it was a true threat, it was entitled to no First Amendment protection. So are you saying that this should be entitled to no First Amendment protection because it's obscenity? Or are you saying that the standard under which we look at it should be lowered, so it's not strict scrutiny, it's intermediate, or it's rational basis or something else? It seems to me that you've sort of said both things at once.
It's alternative arguments. I mean, the first one is that we think the statute regulates obscenity. The way the statute is defined, it targets obscene speech. So that, therefore, it's not entitled to any sort of heightened scrutiny. And then our alternative argument
So it
is-
doesn't matter then if it's obscenity, all the issue of what it does to people or all the stuff that's in the amicus brief and that sort of thing is irrelevant. It's just obscenity, and we don't have to get into any balancing about what the interest of the state is.
Right, I mean, I think then you just go back to a rational basis kind of review that this statute easily satisfies. And then the other argument that we make is that it also is a protection designed to protect personal privacy, and that at most, under Supreme Court precedent, that should be subject to intermediate scrutiny.
What reasonable expectation of privacy did the complainant have in the image that she sent over the internet to her former boyfriend?
The facts as alleged in the affidavit say that she sent it privately to a private message account that only he could see, and that hasn't been challenged.
In this day and age, you think anybody's got a reasonable expectation of privacy to images they send over the internet, to whether it's a private account or directly to WikiLeaks?
I think we do, and I would point to the U.S. Supreme Court's decision, and I believe it was Kwan, just in the Reef, which involved a work issued device and text messages issued on a work issued device, and the recognition that this is how people communicate in this day and age, and that people's expectation of privacy doesn't go away because they're communicating via text message or using their cell phones to send private messages to each other.
But here's the problem that I have with your argument. He did not ask to have this sent, or had no even knowledge that it was coming based on the facts as I've read it. So you have someone who sends it unsolicited to someone she used to have a relationship with. How does she know what he's going to do with it? That's different than if they're engaged in a relationship and, wow, wasn't last night great? This is just unsolicited sending it.
And I think, and that goes to sort of an as-applied challenge to this case. And the facts, as stipulated, was they had been in a relationship. There's not any information about what the current nature of their communications were, other than that she sent these pictures privately to him. And I think that satisfies the expectation of privacy, but even if it does not in this case, it wouldn't be a basis for holding the statute facially unconstitutional.
Is it your understanding, you mentioned this isn't that would be an as-applied argument. I was trying to sort out, I read the trial court's decision as more of a facial flavor. Are we on review considering both a facial challenge and an as-applied challenge? Or should I be asking your counterparts that? Are you defending both a facial and an as-applied?
Yes, we'll defend both, but I think the decision was struck the statute down facially, and then there was kind of like a postscript that talked about some as-applied issues, which I don't think that analysis is really relevant to the facial analysis, but we pushing back against that also. And going back to the issue of privacy, the U.S. Supreme Court has distinguished between public and private speech in a variety of contexts. It has done it in the context of press rights and their ability to publish information. It has done so in the context of defamation and related torts, such as false light and intentional infliction of emotional distress. Most recently in Snyder v. Phelps, where the court indicated that speech about purely private matters could be subject to less rigorous First Amendment protection. And it also made the distinction in San Diego v. Roe, which was concerned the ability of the police department to fire an individual who had been making sexually explicit videos. And it made the distinction that, if it's about a private matter, then the First Amendment doesn't come into play in that analysis.
You started in saying that this is a case in which the plaintiff had a reasonable expectation, or the victim had a reasonable expectation of privacy. And I'm wondering where that comes from. I mean, we understand a reasonable expectation of privacy in Fourth Amendment law. How did this ever get imported into First Amendment law? It sounds like it's a concept from somewhere else in the Constitution, sort of being picked up and put in a place where it hasn't been applied before.
I think it comes in as that's the compelling state interest that's really at play here, is that the state has an interest in protecting personal privacy. There's no, what someone does in the, in the confines of their own bedroom or, with an intimate partner is sort of at the core of personal privacy. And so that's the interest the state is trying to protect here, along as the harms that come from this conduct. And that's been recognized not sort of as part of the First Amendment, but as a countervailing interest that
So would you
courts have
say
to balance.
that a state could criminalize any invasion of reasonable expectation of privacy? There's a lot of things that you may have a privacy about in your life. Could the state say anybody who discloses something to which another person has a reasonable expectation of privacy is guilty of a crime?
No, I think it's more limited than that, and that it needs to be sort of, point to the public disclosure of private fact tort, which hasn't expressly made it up to the U.S. Supreme Court in a First Amendment case, but it was discussed approvingly by Justice Thurgood Marshall in the Florida Star case, and a number of lower courts have upheld it. And then it looks to whether it's extremely offensive. And that's sort of similar with the obscenity analysis, and that it needs to rise above the level of just any invasion of privacy and to be a really extreme one, which the conduct here is. And regardless of what level of strict scrutiny is applied, we believe that the statute survives. The state has compelling interests in protecting privacy, sexual consent, and the reputation of victims, as well as preventing the harm that is well documented that can happen when these disclosures are made. The statute is narrowly tailored, and less restrictive alternatives are not reasonably available. There's a number of reasons, as set forth in the briefs in this case, of why civil penalties are ineffective in many cases. Plaintiffs' lack of resources, judgment-proof defendants, and so forth. And just one brief point about the corporate policies that defendant mentioned in the brief. While laudable, those have proved ineffective. I mean, Facebook's policy was enacted before the conduct here occurred. One need only read the news to hear about private Facebook pages with Marines and things of so forth, that problem has not been solved by Facebook's voluntary actions. I'll reserve the remainder of my time for rebuttal.
Okay, thank you, counsel.
Good afternoon.
Good afternoon.
The First Amendment of the Constitution protects freedom of expression. The trial court correctly applied strict scrutiny to this statute, which criminalizes the dissemination of nude photographs, and found that it violated First Amendment principles. Of course it did. because although the state has come up with any number of novel ways to get around the Constitution by creating a new category of unprotected speech or expanding obscenity beyond its obvious definition, or by suggesting that the statute could meet intermediate or even strict scrutiny, no court has ever come close to upholding a statute like this that so blatantly infringes on the freedom of expression.
Can the state make it a misdemeanor to distribute confidential information or private information from the doctor's office's files, right? So a HIPAA violation. Can the state make it a misdemeanor to disclose confidential medical information about a patient in violation of HIPAA?
Your Honor, I think that when we talk about informational privacy or about things that are protected by HIPAA or social security numbers or any of those other kind of informational privacy, there's a Supreme Court case that talks about that from 2011. It's NASA versus Nelson, and it talks more about exactly those issues of informational privacy and how we regulate them. And I would say that, to Justice Dooley's point before, there is no separate section of the Constitution that talks about your right to your informational privacy or your right to any kind of privacy. So I do think we could come up with a regulatory scheme where there's a statute that says, here's the things we ask. What was at issue in NASA was that they were asking for information for a background check, and people didn't want to give the information for the background check, and because it infringed on their privacy rights, and they didn't know what would happen. And the court basically said, yeah, you can come up with a system where you punish the disclosure of that, but we're going to say that you have to give it. There's a perfectly logical reason why NASA might want to do a background check, and you can give it, and then you can deal with the system if something were to happen where that information would come out. So I think they could come up with a misdemeanor, and HIPAA penalizes. I don't know that they could come up with a criminal statute, a misdemeanor statute. I don't think that a criminal statute would be necessary.
I'm just trying to figure out why the Constitution would be comfortable with allowing disclosure of all sorts of private information, allowing criminalizing disclosure of confidential information, but not disclosure about the most intimate information or photos that you could do.
I'm not sure that we are that comfortable with criminal penalties for all of those kinds of personal information. I don't think that HIPAA necessarily has criminal penalties, or that it would be okay to penalize those things criminally. But I think that there are statutory schemes that are in place to protect those things, and if they were directly related to crimes, that might be one thing. But I don't think that we have crimes that protect informational privacy. And we certainly don't have a constitutional right to informational privacy.
I was a little unclear after reading the trial court's decision here, whether they ended up in the as a facial challenge or as an as-applied challenge, because it seems like they discussed them both, and at the end, I wasn't sure which analysis applied. What can you help me out on that?
Sure. As you must have guessed, I think it was that they shot it down on a facial basis. I think that the statute that Judge Howard was pretty clear that this was a content-based statute, that disclosure of a visual image of an identifiable person, and I think that that Judge Howard went through why simply a nude image couldn't be criminalized in this way, or dissemination of a nude image. And I think then he brought it back to some of the arguments the state made and said, well, you made those, but that doesn't really apply. And I think maybe the state's characterization that he dealt with the as applied as an afterthought and said, hey, this might not even be the kind of situation you're talking about anyway, where he got into a little bit more about the facts of this case. I guess I said I wanted it to be facial, but maybe I want it to be both. Of course it was unconstitutional, especially applied.
In your view, would the statute be constitutional if it, and this is getting to Judge Howard's concern about the coverage of nude images, if it just dealt with sexual conduct that is visual of engaging in sexual conduct, would the statute be constitutional, or would it have the same problem as you are arguing?
I think that nudity alone has been protected, and we have never declared nudity alone to be obscene. And I think some sexual conduct is not obscene. I think that, I think that the court in Playboy and in a couple, US v. Playboy and in a couple other cases said that sexual conduct may not in and of itself be obscene. So
But-
I wouldn't go so far. I wouldn't say that limiting it to sexual conduct would do enough to make this statute
But the
constitutional.
concern really behind the statute isn't some moral judgment about the titillating effect this content is going to have on the viewer or reader, right? The concern here is the damage of the exposure of the most intimate sphere of an individual's life. If for some reason we lived in a culture where our ears were the most intimate place in terms of privacy, then it would be about ears. It's not because we think, I don't think the statute is about protecting people from titillation in circumstances where we don't think they should be.
I think you're right, Your Honor, but then that gets back to a point that was made earlier in the oral arguments in Schenck, and also maybe that the state made. The fact is that just because when we were talking about Snyder v. Phelps, just because it hurts people's feelings or because it personally insults the family of the fallen veteran, we protect all kinds of. If the state's goal was to protect people from being embarrassed or ashamed or hurt, that's not a legitimate basis to pass a law that limits expression
Well,
either.
we do though, right? Our defamation laws clearly limit speech on the basis of the impact to the reputational interests of the person spoken about. And the Constitution's clearly exempted defamatory speech, except for in the sort of public interest, public figure setting, exempted them from the sort of protection that you're inferring applies here.
Sure, and I think that if the complaining witness in this case had filed a defamation case, that would be fine. I don't think that if they went through the steps of proving defamation and whether this was true or not true or what her expectation was, I don't necessarily know that I have a problem with defamation per se, but I do with making it a criminal law that penalizes and chills expression.
So could the state make certain kinds of defamation that don't fit within the Constitution protected range? Could they make that criminal? Could the state make defamation criminal?
I don't believe they could make defamation criminal, no.
Okay.
But I can't think of a situation, I've done a lot of reading of First Amendment cases, and I certainly haven't found a case that comes close to that. They could make speech incident.
The closest it comes is intention. No, that's still not it. Never mind.
I think the closest it comes maybe in when you could criminalize speech that was incident to criminal intent. If it was trafficking and child pornography and the very nature of it was a crime itself, you could penalize speech in that context. But I don't think you could turn defamation into a crime.
Would the analysis of this speech be different if there were evidence here that the ex-boyfriend had compelled this disclosure in some way? Would that affect its constitutional protection?
I don't believe so. I don't believe that it has to do with that the nature of the relationship between the parties is the defining factor. Or I think it would have helped if the statute was clearer about that, just to make it more understandable. But I don't think it would have helped it for First Amendment purposes. Whether the photos were given during a happy marriage that ends in a terrible divorce, and that's when they end up online, I don't think that changes the analysis. Still, those photos are out there. They were given to somebody, and if that person chooses to put them online, I don't think that can be criminalized.
And if the person took them surreptitiously?
If the person took them surreptitiously, I think that gets into a slightly different category. I'm not sure that, and we have crimes for that, right? Voyeurism is a crime that penalizes that surreptitious photograph taking. And I don't love everything about Vermont's voyeurism statute, but I think that when you talk about that kind of criminal act of taking the picture surreptitiously or drilling a hole in a hotel room and taking videos, or if you're hacking into somebody's computer, I do think that does change the analysis.
And what's the interest that our voyeurism laws are designed to protect?
I think our voyeurism laws are designed to protect they're designed to protect privacy.
I mean, aren't they a recognition that there's something uniquely injurious to an individual to be viewed undressing through their window without their knowledge or consent? That's a harm that we can identify as a worthy of the criminal law's consideration?
I think perhaps, but I think that has more to do with your right to an expectation of privacy in your home, or a right to expectation of privacy in your hotel room, and that part of it being violated or invaded, and I don't think you have that in this situation. I think you have a situation where you take images and you give them to people, or you put them out there and you put them out to give them to people, and I think that once you do that, that changes the analysis.
So now you're talking about your as applied, right? The statute doesn't distinguish between these two scenarios, right? So in order to strike
No.
the statute, we have to conclude that what you're describing as the no expectation of privacy scenario was a significant part of the conduct potentially proscribed.
And I have a second issue with that, which is you seem to be coming back to consent. So if the photographs were stolen somehow, we can think of various ways, or a video or whatever we're talking about here, were stolen. Are you saying you could criminalize it because it was stolen, but not if it was actually given?
Yes, because it would be the act of stealing. I think you could criminalize
You
stealing.
can't, so you can't
I
have
don't
a
think-
offense, you could just criminalize the stealing, right?
Correct.
And
Correct.
then it doesn't have anything to do with the content. It's the same old stealing.
Right, and I also think to
So,
Justice Robinson.
but you can think of non-consensual copying, for example, that isn't stealing necessarily, right?
Right.
So all of us, when we send things out from our devices and everything, have some risk that it'll be intercepted along the way. Somebody will get it, not necessarily illegally, but because these devices are not 100% secure, right? So would that mean that could be subject to this kind of statute? So somebody's just taking it, intercepting it, so it's in no sense consensual. They're just intercepting it and getting it. And then using it, exactly as the statute talks about.
I think that would be a crime. I think that would be hacking or a criminal act, whereas this is not. Does that make sense?
Well, I'm not sure what element is not and which element is covered.
Well, I think that when you're taking, no, I don't, I suppose that it's this. I don't think it would be a problem if you're just pulling images off of, and they're not images that belong to anybody, and we took them because we found them in the WikiLeaks trove and we publicized them in this way. No, I don't think that would be a crime. I do think that if someone hacked into your computer or my computer and took our images, that would be a different story because that would involve a crime.
So the statute specifically exempts, says it doesn't apply to images involving voluntary nudity or sexual conduct in public or commercial settings or in a place where a person does not have a reasonable expectation of privacy. So to some extent, does your argument that on the facts of this case, there's no reasonable expectation of privacy really amount to a challenge to the applicability of the statute rather than the constitutionality of the statute? It specifically exempts, it says on its face, we don't apply this statute where you didn't have a reasonable expectation of privacy.
I think that the statute on its face, which criminalizes any depiction, including a nude image, violates the First Amendment to penalize.
Irrespective of why you did it.
Irrespective of why you did it, correct. I think that the disclosure having to do with public settings or where you might have a reasonable expectation of privacy or not has more to do with, did you do it when you were skinny dipping? Were these photos taken when you were skinny dipping in a lake, or were they taken, did you pose for Playboy and then you're mad now that they're being used? And I think that's what that applies to. I guess that's it.
That's it. Thank you.
Appellant has 1 minute, 30 seconds remaining.
This law is not passed to merely protect hurt feelings or police relationships. This law was a deliberate response to a problem that exists that caused significant harms to young people and people of all ages in Vermont and around the country. There are a number of criminal laws that touch on elements of this practice, but none squarely directed at it, so none were sufficient, and a number of those laws potentially have speech elements to them as well. The legislature determined that passing a law that specifically targets this practice was necessary, and it was appropriate. There's no First Amendment right to disclose someone's nude image without their consent, and there never has been understood to be, so we ask that the decision below be reversed.
The next hearing for the court will follow immediately.